We have a big ruling coming out of a federal trial court that goes against short barrel rifles and machine guns, declaring that they are not protected by the Second Amendment. I'm going to be going through a lot of the arguments here about what they brought up, why it's wrong. You're not going to want to miss this one because even if you do not care about SBRs and machine guns, you are going to care about the reasoning because you will see this playbook come back for AR-15s and just about everything else. So guys, let's get into it. All right, so I'm going to hit you with some quick facts of what's going on in the federal trial court. So basically back on August 16th of 2022, there was an individual later known as the defendant, Mr. Christopher Chan, who basically would be contacted by the Honolulu Police Department. We are in the great Aloha state of Hawaii because there was reports of erratic behavior. Now, before they could reach him in his high-rise apartment, Mr. Chan leaves the building. I'm not going to call it a chase, but let's just say there was a pursuit that wound up having Mr. Chan allegedly endanger different pedestrians and individuals as he was on his way to, I believe it was his mother's nearby residence. Now, ultimately, HPD, Honolulu Police Department, wind up making the stop on the car, and they dig out of the trunk a short-barreled rifle, I think about 10 inches and change barrel, as well as having a conversion to a full automatic machine gun. And that, of course, would be the subject of the indictments, and the indictments were the subject of the motion to dismiss, which is the reason why we're talking about this, because Mr. Chan said, look, these are bearable arms, they're protected by the Second Amendment, and they should be legal, and the laws that basically seek to regulate and quash these are unconstitutional. The government predictably rejects that, denies that, and the judge wound up writing a decision that you will find attached in the description box below in the case of United States versus Chan. Let's get to that as well as the law. The judge, who was appointed by President Obama, started out looking okay when he cites to, at least in part, the relevant law. Citing to the Brune decision, quote, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside of the Second Amendment's unqualified command. All right, so far so good. We're talking about weapons. I would have loved to see some language in there talking about common use and that kind of stuff. But unfortunately, if not predictably, we eventually get to this little guy. Quote, weapons that are dangerous and unusual are not in common use and therefore do not fall within the scope of the Second Amendment. That's right, boys and girls, we're talking about dangerous use again. We did a whole video where we deep dived this last week. Hopefully it's coming up on a card right now if you want to check it out. Came up in the context of discussing a trial that's going on in Illinois right now concerning the Protect Illinois Communities Act, where Illinois is effectively seeking to ban AR-15s, AKs, you name it. And one of the big topics for that entire trial is what's dangerous and unusual. So I do something of a deep dive on that there. I'm going to cover a couple bits of this later on in this video, so be sure to stick around. All right, now this is where I have to get one of those qualifiers out there so that you don't confuse me with a President Obama appointed judge or the United States Supreme Court. Not that that happens too often, but when it does, it's always in the comment section. I did not write the 2008 Heller decision. That's the United States Supreme Court decision. So when they said, and this court in Hawaii cites to, quote, we think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Heller is not citing to Tom Grieve. They are citing to a very important 18th century author by the name of William Blackstone. Quick story here coming up on that. Heller basically creates the lane that all of these anti-gun judges and groups are trying to jam AR-15s, AK-47s, and of course, SBRs, short barrel rifles, short barrel shotguns, machine guns, you name it, into. And that's the loophole of dangerous and unusual weapons are not protected by the Second Amendment, and therefore you can basically regulate them to your heart's intent. Yes, that is low resolution. I appreciate that. But stick with me here, all right? Give me a little artistic license. Be sure to stick around to the end where I'm going to give you 3 big takeaways on this whole thing. Also, of course, our ever popular quote of the day. Don't forget to hit that like button. Now back to the video. Okay, so we've got this dangerous and unusual weapons are not protected by the Second Amendment. And it's key that it's not dangerous or unusual. It's dangerous and unusual. We're going to be talking about the numbers in a little bit here. I've got the specific numbers for short barrel rifles. But where did this all come from? Because that's very, very important here. Remember, we're talking about history and tradition as being, in a lot of ways, the backbone of how we are to understand the Second Amendment. So when Heller in 2008, the United States Supreme Court in 2008, cites to William Blackstone, what was Blackstone talking about when he was talking about dangerous and unusual? Well, he was talking about the fact that you cannot have weapons that are dangerous and unusual that you're using to terrify the people. This is part of a class of offenses known as affray offenses. In other words, you're not looking simply at the mere possession of the weapon unto itself. We're taking that as part of the important context of what we are doing with those weapons. And if you don't want to believe me, the guy on YouTube for it, I understand that. But the good news is you don't have to, because we've got history and a quick story coming up. So there was a case back in the middle of the 1680s. Yes, this was not something that's cherry picked. It winds up being continued and cited all throughout the 1700s and even 1819. We're going back to England. We're going back to just before the Glorious Revolution for you history students out there. I know this is not going to be boring. Stick with me. So the government, we're talking about England, charged this individual by the name of Sir John Knight, who was a prominent critic of King James II, with violating the statute of Northampton because he allegedly, quote, did walk about the streets armed with guns, and that he went into the church of St. Michael in Bristol in the time of divine service with a gun to terrify the king's subjects, end quote. So notice that even in the charging language, so to speak, the accusatory language, they included to terrify the king's subjects. Now, they're not doing that because it's fun. They're doing that because they need to. It's an element of the lawsuit. Chief Justice further explained one's conduct will come within the act being what he's being charged with here, i.e. would terrify the king's subjects only where the crime shall appear to be malo animo, end quote. That means we're talking about evil intent or malice. Knight was ultimately acquitted by the jury. Why? Because he had death threats on him and he was going about armed, not because he was trying to terrify people, but because he was trying to protect himself. Keep in mind, 1680s, handguns and firearms, not exactly the most common thing that are kicking about. Hence the argument for these are dangerous and unusual weapons. And even then, they said, look, it's not the mere possession. We're seeing historical malpractice, if you will, of understanding what Blackstone was talking about and misunderstanding, I would say, what the United States Supreme Court was talking about when they alluded to this notion, this principle, this doctrine of dangerous and unusual. It's not just dangerous and unusual. There's a dangerous and unusual comboed up with the context and how it's used. And of course, this belies the fact that is a short barrel rifle, let's take AR-15s, is an SBR intrinsically more dangerous than a regular AR-15? It's mildly lighter, mildly smaller. Is it really going to change how you use it all that much, absent getting in and out of cars while in full kit? Probably not. The terminal ballistics get a little bit worse. Is that very meaningful in a defensive action? Probably not, at least not if you have shorter engagement distances. How's an SBR more dangerous than an AR-15 pistol, which is absolutely legal? The buttstock is slightly different, but to an untrained individual, these are identical firearms. Yet one is perfectly legal, and the other one is a felony subject to federal and state indictments. What's going on here? And of course, all this belies the fact that while there may be qualitatively little to no difference between these rifles, combined, we're talking about AR-15s and AR-15 pistols, 24 million plus in the United States alone. I know what a lot of you are going to say, but what about the 2016 Caetano decision That's Caetano for those of you driving, those of you riding your lawnmowers right now, and you can't see the words on the screen. What about the 2016 Caetano decision? That was the decision where the United States Supreme Court, in a per curiam decision, in other words, they all agreed on it, struck down the Massachusetts law that bans stun guns, and in a concurring opinion, in other words, it's not really part of the law, it's another judge that is agreeing with it, with what the court did in this case, but they're writing a concurring opinion to kind of put out some of their own reasoning. They cited the fact that there are a couple 100,000 stun guns in circulation. Here we have about 532,725 short barrel rifles, or SBRs, so nearly double the numbers, probably actually a little bit more than double the numbers of what we have for stun guns back in 2016. So, hey, shouldn't we just be good on the, even if you want to say it's dangerous, it's certainly not unusual. Look at Caetano, stun guns were good. Well, the court basically says, look, this reasoning was not adopted by the majority. It wasn't part of the decision. It was only part of this concurring opinion. And even so, the court went on to argue, and we've seen this before, and we will see it again, that those numbers mean little about whether or not it's telling us that SBRs are in quote-unquote common use, let alone if they are in, and here's the goalpost moving, in common use for self-defense. Keep in mind, the antis are trying to say that it's not good enough that something's in common use. It must be in common use for self-defense, which would, of course, would eliminate, well, a lot of different firearms that are protected. But if you want to know more about that argument about in common use versus in common use for self-defense, let me know in the comment field down below. For now, we press on. Now, the government tries to turn this 500,000 and change SBR number around by pointing out that that is, according to them, approximately 0.13% of all firearms in the United States today. They're, of course, making the argument that, hey, how is 0.13% in common use? Here's the problem with that logic. If you want to get super intersectional with this, let's take cars as an example. Chevys are, I think by anyone's definition, in common use in the United States when it comes at looking at what are the vehicles on the road. But we can really start to parse this by, well, Cadillac, GMC, Chevy, and then let's start looking at specific types of things. Let's look at a specific car. Let's say a Tahoe. All right. Well, Tahoes, we're no longer talking about the 23% of cars that are Chevys. We're now talking about whatever subset are Tahoes. So can the government ban Tahoes if there's some sort of common use Tahoe car test? Well, now let's further break it down. We've got different editions of Tahoes. We've got different years of Tahoes, different lines. We've got, does it have leather? Does it not have leather? What's the engine type? Does it have bucket seats in the second row versus bench seats? We start talking about colors. We start talking about wheels, all this other kind of stuff. You can see how you can get to the super intersectional game here so that virtually there's nothing that is in common use if you just want to keep splitting hairs. And again, this is a tactic that I've seen in other lawsuits and in other arguments that the government's using here. And I just want to put you guys on notice that you know it's out there because it will keep coming back. Another thing that this court basically rests its hat on when talking about SBRs is the fact that, look, there are 9 other federal district courts out there, including Minnesota, Western District of North Carolina, North Dakota, Nevada, Southern District of Illinois, Eastern District of California, Southern District of Mississippi, Connecticut, and Northern District of Oklahoma, who have all decided that short barrel rifles are dangerous and unusual. They're just basically going to be putting their name on a list. And here's the last big argument that the court uses to basically say short barrel rifles are dangerous and unusual. They quote Heller. And Heller here is talking about the 1939 U.S. Supreme Court decision, which talks about Miller, which is upholding broadly the National Firearms Act and, of course, short barrel shotgun prohibition. I'm happy to deep dive Miller, Heller, and how this all plays together. Again, let me know in the comment field down below. If enough people want it, I'm more than happy to go into that. So this is what Heller says about Miller. Quote, "We therefore read Miller to say only that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short barrel shotguns, period," end quote. Number one, they didn't say for self-defense. They said for lawful purposes. So, it's interesting that, of course, this same court is saying they're trying to bring up this anti-gun for self-defense purpose when they're then later on quoting Heller, the United States Supreme Court, which talks about for lawful purposes. But, setting some cognitive dissonance, That's a politically correct way of saying hypocrisy and some other issues to the side. We've got this issue that Heller has basically blessed short-barreled shotgun prohibition. And short-barrel shotgun and short-barrel rifles, if you can ban one, why can't you ban the other? In essence. So you can see how the court is going to build on Miller, on Heller, on the 9 other district courts, the federal trial courts that are out there. They're going to use intersectionality to parse these numbers down to 0.13%. They're going to use all of that to ultimately deny the motion when it comes to short barrel rifles. So what about machine guns? Well, basically there was a 9th Circuit Court decision. So remember, that's the circuit court that sits over Hawaii. So basically its decisions are controlling for Hawaii. And the judge in the Hawaii case here, Chan, says this: we don't think, or I don't think, that the 2022 Brune decision by the United States Supreme Court fundamentally changes the logic that that decision was based on, that the Henry Court in the 9th Circuit used to determine that machine guns are dangerous and unusual. Therefore, decision still stands. Therefore, machine guns are still dangerous and unusual. Done. So there's basically 3 things as part of this outcome. Number 1, SBRs and machine guns are not protected by the Second Amendment because they have been found to be dangerous and unusual by this Hawaii judge. Number 2, if you're panicking about number 1, don't worry. This case is of 0 precedential value because this is coming from a trial court, not a federal court of appeals. It's not coming from a state Supreme Court, and it's certainly not coming from the United States Supreme Court. Those are the precedent-setting courts. But as you already saw in this case, it can create what we call persuasive precedent in the eyes of other courts and judges to see what other people are doing, other judges are doing, and then they can bandwagon along. Number 3, however, this could go to the 9th Circuit Court of Appeals and maybe even beyond to the United States Supreme Court to ultimately shape our laws that control all of us on short barrel rifles, machine guns, and who knows, maybe SBS's, short barrel shotguns, destructive devices, AOWs, any other weapons, you name it. We appreciate you sticking around this long. What do you think is going to happen with this case? What do you think is going to happen with these laws? Do you think SBRs at the end of the day, 5-10 years from now, are going to be found to be constitutionally protected, or they're dangerous and unusual weapons, or something else? Let's close out with our ever popular quote of the day. This one comes from the Romans, and it comes from Mr. Sulla, or Sulla, S-U-L-L-A. Quote, "No better friend, no worse enemy. No friend ever served me, no enemy ever wronged me, whom I have not repaid in full." End quote. Kind of a fun one, slightly different than usual, but hopefully you got something out of that. We appreciate you sticking around. Don't forget to hit that like button, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.